Hello, everybody. It's Margaret here. So happy to be discussing some more company policy training with you. And as we announced 2 weeks ago, the company policy training today is very interesting. It's on testamentary transfers, or in other words, what happens to your business should you pass away. But let us first go through the normal welcome, everybody. Can you hear me? Can I just have a few hands telling me that you can hear me? Or just chat on the box telling me, can you hear me? Hello? Oh, excellent. Thank you so much. That's Margaret Taba telling me everybody can hear me. Thank you. So now we can proceed. Let us begin today's training. And let's see what the next screen tells us. So welcome, everybody. We have the normal introduction we have because we never know when we have new people joining us for the first time. So we, human beings, we learn by repetition. And so the first few screens, we repeat every time we have training for the new people and for others, just to remind them that as forever business owners or FBOs, it's essential to uphold the values and policies of Forever Living Products. Recruiting new members into the Forever business is a responsibility that comes with ensuring they understand the company policies, procedures, and compliance standards. The role of the upline. Everybody that has sponsored someone else into this business is an upline, and everybody that's in the business has an upline. So the upline refers to the sponsor or mentor who introduces new FBOs into the business. It is the responsibility of the upline to guide and support new recruits, ensuring they are well-versed in Forever company policy procedures and compliance. You will be surprised how many people that could even be managers are asking basic questions, which tells me they haven't read the company policy, and I worry about what they're training their people. What are they training their team? To ask questions is not a problem. We are here, and you can ask me the same question 25 times. I will repeat it until you know it. Please do not be afraid to contact FBO support with any questions of any sort about the company policy or the marketing plan. So once again, we'll tell you the support from the Home Office and the FBO support team in Southern Africa are dedicated to assisting FBOs in understanding and complying with policies. So make a note of this number and this email address. You can reach us at email fbosupport, one word, at forever.co.za, or we have a WhatsApp support number, which is, if you're in South Africa, 064-636-8968. If you're outside of South Africa, it will be +27, and then you drop the first 0, and then just 64-636-8968. We are here to assist and guide you in all aspects of your business. This particular number is not used to submit orders on. In fact, no orders anywhere should be submitted on WhatsApp, email, or online, or any other manner. Biashara Act, do not ever send orders on WhatsApp, because we don't have a record of that, and we won't be able to assist you if there's something wrong. So remember FBO support and the WhatsApp support number. Then, as you know, all these company policy Zoom trainings, they are all recorded, and you can watch and catch up on company policy training by going to our YouTube page. There it is, Forever Living Products Southern Africa, or joining Forever Southern Africa, that's the group, -FBO training and support Facebook group. There you'll see all our programs, all our recognitions, Power Hour is there, Step Up is there, product training is there, company policy training is there. What matters most? Everything's recorded, and that's where you will find it. So make a note of these accesses to YouTube. Or YouTube, you would click on company policies and look on the right. There, right at the top, is the very first training we did on compliance. That was February. And then we did quite a few on online ordering, ordering procedures, email ordering, online registration. And then we moved to marketing plan and bonus recap. We did 2 trainings on that, 3 trainings, and then we went to Eagle Manager and we did responsoring policies. And last week we did retail selling. And today we're doing testamentary transfers. These are on, this recording will be on roundabout after 1 o'clock today. And I would gather a few of your team members and go to the recording, and they can listen. You can stop it when you want to. You can ask questions. We will have a question, always have a question and answer time at the end of every session of recording. So please take a note of this and know that it's available for you. Even if you've got people that are working now and are not able to attend this training, they can watch it after 1 or this evening or tomorrow, whenever. Get some people together, and that's how we learn. We learn by repeating things. So today's topic, testamentary transfers, and you will find this in the company policy that's dated May 2024. Section 18.02, and that comprises pages 46 to 49 in the company policy. In blue, something very important. This is a subject that many people do not enjoy discussing. However, it is essential that such matters be discussed and legal advice sought. You want to know what happens to your business should you pass away. This is a willable business. Your children can take over, your grandchildren can take over. Well, if you leave it to your children leave it to their children. And that is what forever is all about. But without a will or certain points that will be explained during this presentation, things can fall apart. So please pay attention. We'll do this slowly, and hopefully you'll understand, and we'll have time for questions at the end. It's actually very simple. You just have to pay attention. So, to begin with, the transfer or assignment of a forever business is prohibited. Prohibited meaning not allowed, except in the event of death or legal separation or divorce. So often we'll get, I had a request about a year ago from a couple that said they are very old and they're not well and they want another person to take over the business. When you look at it like this, it's not allowed. But when we see a special thing like that, we refer it to the legal department in America. And this instance, it was also not allowed. So there are certain things. Remember, you're running a business, and the legal department will have the final say in certain matters. So on the right-hand side here, you see a blank application form. We're going to talk about the blank application form. If you look in the first line, all forever business owners applications that contain 2 signatures. Do not be alarmed, because many, many years ago when I started here, there was 2 fields, a field for a principal and a field for the spouse. And there were 2 signatures. If you were husband and wife, or 2 sisters, or mother and daughter, or whoever you decided to join the business with, both names went on. Always the principal, meaning the person, the money is only ever paid to the principal, and 2 signatures. So it's referring to people that joined before 2014, because that's when they changed it to 1 name. and one signature, okay? So if you're an older, not an older person, but a person that joined the business many years ago, before 2014, and your application contains two signatures, regardless of when signed, shall be treated as creating a joint tenancy with right of survivorship. That means you're seeing the business belongs to the two of you, and whoever survives the other one, they will automatically inherit the business. Let's carry on from there. If the FPO lives in a community property state, the treatment will be that of community property with right of survivorship. So if you've got two people, two signatures, and they are married in community of property, most people today get married in, they've got all these fancy names. You know, I got married a long, 57 years ago, community property. So when my husband passed away, automatically everything was, I inherited everything. That's what it means. If you're married in community of property, today you get, what's it? I can't even remember the names. I know you get things with accrual and these modern things, but you know, the older people, we didn't believe in divorce. Our parents didn't get divorced. I'm not saying there's anything wrong with divorce, but we got married the way our parents got married. And that's, I found myself married in community of property. On the confirmation of death of any one of the two signing FBOs, the forever business will automatically be transferred to the survivor of the two. That's if you are married in community property. This will be the case regardless of what is stated in a will of the first FBO to be deceased. Now, it might be, let's say you've got a husband and wife. Let's say the husband's the principal, the wife is the spouse on this form from long ago. And let's say the husband has a son from a previous marriage. And the will says that the business will go to that son should he pass away. If you read that fourth paragraph, this will be the case regardless of what is stated in a will. So two signatures on an application form, and they are married in community of property, the survivor spouse will receive the business. Never mind about the son or the other person stated in a will of the first person to be deceased. In addition, this means that when two persons have signed on the forever business owner application, the survivor of the two will be the sole FBO after the death of the first. That's the way it's stated in the company policy. If an FBO does not wish this result, they may contact the Home Office to express his or her needs and to determine if such needs can be accommodated. Keep in mind that no change in a forever business can be made during your lifetime, except in the case of a legal separation or divorce. So you can't decide you're not feeling well, you want to give this business to your sister, or whatever the case may be. No change in your lifetime, except in the case of a legal separation or divorce. Okay, let's clearly look at the most important part here. You see on the right, once again, the top section of the application form with special emphasis on that block next to the word married. Let's read what it says on the left. If the distributor application of a legally married person has checked the marital status box as being married, so in that little box in that red circle, you've got a tick or a cross. But the application only contains the signature of one of the married parties. That means you joined after 2014. The company will treat the forever business as being a joint tenancy with right of survivorship. So if you are married, but there's only one name, but the person, the person on the principal person is married, and the principal person's signature is on the form. That means the fact that he's ticked the married box, that means the spouse will automatically get the business. So may I just mention at this point, some people join the business single and then they get married. Unless they send us an email with a marriage certificate specifically instructing us to pull the application and change that little box to married. It should not be the staff's responsibility. What should happen is that you should send us your copy. Everybody's got a copy of the application form that they kept. It's either pink or blue from way back. They must change that and send us a copy of the marriage certificate with strict instructions. Because if someone passes away and sends us the will or the death certificate and the application, and we see that that application is not ticked married, can you see the implications here? So this is something to tell somebody when you're telling them about the business and they are single. Just please mention this to them, how important it is that they change that to married, but they have to send us an email. Don't just send us a marriage certificate and expect us to do the rest or know what to do with it. You have to give us instructions and keep a copy of that so that if there's any dispute, you've got your instruction to us and we should have it on file as well. I hope that bit's understood. Let's go back now to the second paragraph on the left. Forever business owner applications that have the marital status box checked as being single and with only one signature will be treated by the company accordingly. A single person must have a will. A single person can put into that will the fact that they want to leave it to their parents or a sibling or a nephew, niece, or they can say I'm not married, but to my wife at the time of my death. That would also cover the married box not being ticked. Please, FBOs, managers, whoever's listening to this Zoom, it's very important that you join this business and teach people about the end, the what ifs, what is going to happen to the business. It's so very important. Okay, to transfer a single person's forever business on death, such FBO must have a will or use of a grantor's trust. So grantors is an American expression. You hear many people have said, I have established a trust for my children. So a trust will be done either by an accountant. I'm not sure about bank managers. The people I know that do a trust have done it through an accountant. And there'll always be a witness, and there'll always be someone in charge of the trust in the case of your death. Let's read on about that. The company recognizes joint tenancy with right of survivorship and use of grantor trust as legal means of holding a forever business, and in the event of an FBO's death, a means of transferring the forever business to the survivor or named beneficiary, respectively, without having to go through probate proceedings to get the property to be the intended heir. So if you've got a will and you've got a trust, if your children are under the age of 18, that's the legal way of transferring the business without backwards and forwards to attorneys and accountants, etc. If the forever business is held in a business entity, the death of the primary shareholder will not remove the forever business from the business entity, so long as the ownership of the business entity remains in conformity with company policies governing ownership of such business entity. This means many people normally married couples, but it could be anybody, They often change their business to a business entity. And they think that that will bring both names into the AS400. The corporate name is entered in the business entity, or corporate name is entered on the AS400. But remember, when they joined the business, the name, one name or two names, depending on when they joined or how they joined, will still appear on the AS400. It doesn't change. We never recognize business entities. We always recognize people. So even if you are in a business entity, there will always be a primary person. Even if the business entity is shared 50-50, it's normally 51-49, the split. But in the event of it being 50-50, the person that joined the business, that is the person that will inherit the business should the other person pass away. If the primary person passes away, they will not be remove the business entity as long as the ownership, which is now the other party of the business entity, remains in conformity with company policies governing ownership of such business entity. So if you have a husband and wife, whether it's 50-50 or whether the split is 51-49%, whoever the surviving spouse is will carry on with that business entity as long as they stick to company policy. In red at the bottom, the transfer will be recognized by the company when a court order or legal documents addressing the transfer are submitted to and approved by the company. So we always will need something legal telling us that we can proceed and we can transfer the business to another name or adjust whatever needs to be adjusted. It can't be done in an email. We will need a legal document. And a will is a legal document because it would have been signed by a commissioner of oaths and people, legal people. I hope that that's understood. Okay, so now someone passes away. Within 6 months following the date of the FPO's death, the surviving FPO, trustee, or estate representative shall provide notification of such death to his or her domestic home office of FLP. Such notice is to include the following: a certified copy of the death certificate, a certified copy of the will or the grantor's trust, a copy of the court order authorizing the transfer of the forever business to a qualified successor. So normally we don't have a problem. The family normally let us know, someone or the upline manager or someone will say, so-and-so has passed away, what must I do? And we will tell them, please send us a copy of the death certified, copy of the death certificate, copy of the will or the grantor's trust, and a copy of the court order authorizing the transfer of the forever business to a qualified successor. If that's the case, depending also on what the application form says, whether they're married, whether they're two signatures. Remember, a few screens back, we discussed that. They've got 6 months in which to do that. Often people pass away, rarely, or maybe if they weren't that active, and nobody has let us know that they've passed on. We won't know to make any changes, and that person will be sitting on the AS400, and the upline, depending how close they are to one another, will just think, oh, well, you know, she must be less active or whatever. That's why it's so important to take good care and to stay close to your downline. But nothing will happen unless we get notified of the passing away of someone. Also, after 6 months from the date of death, FLP may remove the deceased FPO from the forever business. Giving timely notification and providing the required documentation for a successor's interest will be required to prevent a suspension and or termination of the forever business. So I have never had an instruction from America to remove a deceased person. As mentioned before, they will just appear on the system as though they are less active. And anything done by their team will just jump to the sponsor or above. Just today, there's no difference between someone being less active and someone having passed away if we don't get notification of it. The marketing plan will stay the same, the way it is now. If based on valid reasons, a request for a reasonable extension of time to provide transfer documents may be submitted to the deceased FBO's FLP domestic home office prior to the end of the 6-month period. We did have something like this many years ago. Someone in Durban passed away and the family was scattered and they asked for an extension of time past 6 months to get some documents sent to us, and America did grant us that. I've only ever happened once. FLP reserves the right to make payments to the joint survivor, beneficiary, trustee, or legal authorized personal representative of the estate of a deceased FPO, pending the timely submission of appropriate legal documentation. So, depending on what notification you give us, I've got a lovely example at the end of this presentation that I want to share with you. FLP reserves the right to make payments to the joint survivor or whoever's in charge of the trust of the deceased person, pending the timely submission of appropriate legal documentation. I've never had problem with the biggest challenge we have is that there is no will. And often we have children saying, or the spouse, the survivor saying, my children want to take over and they're this and they're well educated and they're whatever, and we can't do it without a will. In the odd instance, we've sent it to America. We did have an instance where a couple was engaged to be married. The lady had a little boy from a previous relationship. They were staying together and raising the little boy together. She passed away sadly, and her parents, I can't remember if there was a will or not, but her parents wrote a letter to us saying that I think there must have been a will. And they said they are old, and they sent an affidavit and all the legal documentation, and they said they are old, very old, and they would like the fiancé who was raising the child together with their daughter to carry on, to have the business and to carry on raising the child. And we sent everything to America, and they agreed that that could happen. So when there's something out of the ordinary, do not give up hope. We'll send it to America and our legal department will make a decision when things are just slightly different, if you know what I mean. Okay. The inheritable rights to a forever business are limited and restricted as follows. The heir must be a person who can qualify as an FPO. So the heir means the person named in the will normally. So that means they must be 18 years or older. Because the heir must be an adult individual, a trust or guardianship may have to be established for multiple heirs or minor children. So you've got 3 children and they are 12, 10, and 6. Let's just say that. In the event a trust is established, a copy must be placed on file with FLP. Its terms must clearly allow the trustee to act as an FBO. A guardian or a trustee of a testamentary trust must be appointed by the court of proper jurisdiction and receives specific approval to be an FBO on behalf of the minors. So to summarize that, you've got 3 children under age of 18, you've established a trust, and you've established, you decide who the guardian or the trustee will be to act on behalf of the children. You will establish that with either an accountant, I'm not sure about an attorney, one or the other, I'm not quite sure. Should you pass away, that trust will become the main thing of transferring this business to your children. But the guardian or the trustee, the person appointed by yourself, must then be appointed by the court of proper jurisdiction and receive specific approval to be an FBO on behalf of the minors. Now, you may be thinking, but why must they be appointed by the court when I have asked? Let me give you an example from my personal life. I have many brothers, one of whom is an accountant. My husband appointed him as the executor of the will. It's a similar thing, whether it's a trust for minor children or whether it's a will. It's basically on a legal point, it's the same thing. So my husband appointed my brother as executor to his will. And I've appointed my brother as executor to my will. Now, I've just lost my son a few months ago. In his will, in his estate, there is a motor car belonging to my grandson, which is still in the name of my son. So my grandson can't sell the car. He can't do anything with the car because it belongs to his father. My brother, the executor of my son's estate, has been appointed as the executor, but that executor still has to apply to the Master of the Supreme Court, and the Master of the Supreme Court has to say, yes, you can be the executor, or no, I don't approve. What if my brother has lots of debt and he's not a very nice person? You know, the government has everything, SARS and SAPS, have everything on you. So what if the executor, the court, the master of the court looks at this person that's been appointed as the trustee or the executor and says, no, this person's got too much debt. No, this person can't work responsibly with money. No, I don't approve of this person being the executor. I'm fortunate that my son passed in January. Just last week, I got a letter from my brother saying the master of the court has approved him to be the executor of my son's estate. And he has the power now to say what happens to that car. So now my grandson can sell it or do whatever he wants to with it, because the executor becomes the owner of the car. And I hope that you don't mind me saying executor, guardian, or trustee. It's exactly the same principle used here. That let's say you put up a trust for your children and you appoint your brother or sister or someone, and you've done that 5 or 10 years ago. Now, let's say something, heaven forbid, something happens to you, but in the meantime, that person that you've trusted has become a gambler. You don't know that person has a gambling problem. Now, the court will have a look at that person's conduct. They'll check the bank statements. They'll check everything about you. And they'll come back and they say, no, this person can't be the trustee because this person can't work with money. So then the court will appoint another person that can work with money. I hope that this makes sense to you, because, you know, you appoint people in good faith and then you don't know what happens 10 years down the line. I hope I've explained that in a way that can be understood. Let's go to point number 3. A trustee or guardian shall retain the FPO status as long as the forever business owner's agreement is not violated, until the beneficiaries have attained the age of majority and an heir accepts the responsibility of operating the forever business with prior approval of the court. So that person that you have appointed to be the trust for your children will retain the FBO status. In other words, that guardian will become the FBO. As long as they don't, nothing is violated. When the beneficiaries have attained the age of majority, the age of majority is normally 21, but you can join the company at the age of 18. So at the age of 18, that trustee and children should be talking to one another. Let's say the child is 18, either in matric or maybe early years of university, and says, hey, you know, I'm not quite ready to accept the responsibility of operating this business. You know, I need my studies. Let me first finish my studies. That person, the trustee or the guardianship, can hang on to that beneficiary until the child is ready. It says there, and an heir, that's the child, accepts the responsibility of operating the forever business with prior approval of the court. So those are the things that are to be looked at. Let's go to point 4. A trustee, guardian, spouse, or other representative type, FBO, shall be responsible for the actions of the beneficiary or his or her spouse for purposes of following the policy terms of the forever business owner agreement. A violation of company policies and the code of professional conduct by any of the above individuals may result in termination of the forever business. So, one has to be very careful. So the beneficiary is actually the child. But the trustee, the guardian, the spouse, or any other represent will be watching the actions of the children, or maybe the children get married, he's her spouse, for purposes of following the policy. A violation of company policies and the code of professional conduct by any of the above individuals may result in termination of the forever business. Point number 5. The inheritable forever business position within the company marketing plan is limited to recognition at no higher than that of manager. However, bonuses shall be paid at the same levels and requirements as held by the deceased. All sponsored managers belonging to the forever business will be reclassified as inherited managers who can subsequently qualify as a sponsored manager as outlined in section 5.04E. Forever business positions below manager shall be inherited at that level. If we go to 5.04E, where they talk about inherited and transferred managers, a manager is considered inherited if he or she is moved to a different sponsor under the 12-month leadership bonus qualified rule, or if his or her sponsor is terminated or responsored. In such a case, he or she becomes an inherited manager to his or her new sponsor. And the reason, let's say a soaring manager has passed away and she has 5 managers. Those 5 managers, first of all, the person that inherits the business will become a manager, not a soaring manager. And all the sponsored managers will be reclassified as inherited managers. And that's because the person who inherited the business did not bring them to the level of manager. The deceased person brought them to the level of manager. They can subsequently requalify as a sponsored manager by doing 120 cc's in 2 consecutive months, or 150 in 3 or 4 consecutive months, and most importantly, being 4 cc active both months of the move up. So you will no longer be a soaring manager. You will be a manager, and you will not have any managers. You'll have inherited managers in your downline that can become sponsored to you once they've done the necessary criteria as outlined in the company policy. Okay, very important. That's why it's blue. Look at that lovely happy family on the right there. We often receive requests from family members detailing the passing of an FBO and requesting to take over the business. This cannot be done without a copy of a will. The person wanting to take over the business must be mentioned in the will. The business is a willable asset, and we should put plans in place for our children or family to inherit the business in such a manner that it all goes smoothly. Very important. This is the experience that I want to share with you. Many, many years ago, where the FBO and his wife were both on the application form. He passed away, I'll never forget this, he passed away on the 8th of a month. And bonuses, as you know, are paid on the 15th. I had 7 days, and all I could think about was this FBO widow, and she had a young child as well. And I thought, oh my goodness, the first thing I did once I got the death certificate. That's all I got. So I knew he'd passed away. Both signatures were on the form, so I didn't have to worry about a will at that point. And I thought, I've got 7 days before payment's done. So the first thing I did was take off his banking details. And I thought, I know this widow is now in deep mourning, and I have to talk to her. I have to ask her for her bank details and a copy of her. I says here, yeah, so maybe I didn't have the death certificate, but how would I have known that he was passed away? I'm sure I did have the death certificate, but I couldn't do anything with the money until I had her bank details. So I phoned her. I gave her 2 days of mourning, and then I phoned her with a very heavy heart. I felt so bad because I personally knew this man. I phoned her and I said, I am so, so, so sorry with the passing of your dear husband. And I know that you are still very much in a period of mourning and will be for a long time. But in a few days' time, bonuses will be paid. And I need this money to go to you. And she was so grateful. I was so embarrassed, and she was so grateful. And she immediately, later that day, I received her bank statement and I received her ID. And immediately we changed everything on the system. And I don't want to mention the amount, but it was a lot of money, a lot of money. And on the 15th of the month, the money was in her account and absolutely no hiccups. And that's the way it's supposed to work. We've had a couple like that without any hiccups. And the only time we've had a hiccup is when there's no will or no death certificate. Those are the little things that cause hiccups, but we do the very best we can to keep to company policy and to make sure things work out the way they're supposed to work. So I'm just sharing that with you so that you can see that it really does happen, and it happens as smoothly as possible when everything is done accordingly. So we always remind us one another to let's work together to build a future for our children or the loved ones left behind. That's what it's all about. If you ask many FBOs, why did you join this business? Jane Leach will tell you, I joined this business so that my 2 boys could go to a private school. It's all about the children and the ones left behind. So let's do the right thing to ensure the future for our children and our loved ones left behind. So now we announced our next company policy, will be done on the 3rd of September. And the topic is one that we've done before, but we're going to repeat it. We're on a new program called Titan, and this is on the website, online ordering. Online ordering is so easy, and it's the way to go. It is the new way of doing things, quickly and painless. So that's our next, make a date, the 3rd of September, and the topic is Titan website online ordering. So it's time for general discussions and questions. Thank you for listening. I hope it was clear enough, but I'm here if you need to ask us some questions, and we have about 8 minutes. Let me see. Joey Nell, makes sense. Sorry, go down.
Step from the beginning.
Yes, you obviously weren't here at the beginning, Shipoki. Now's the time to ask questions. Someone's answered after the presentation. Oh, I've answered the question you wanted to ask. Well, that's great. I'm happy about that. Email where to send our instructions. You obviously weren't here early, my sweetheart. FBO support. FBOSUPPORT at forever.co.za. It makes a little bit of sense. It's clear. Thank you. Wonderful. Wonderful. I'm so glad that you can enjoy that. Very educative. That's great. That tells me people understand. You have a question, Katie? Okay. At the end, now's the time to answer it. Okay. So, that's great. I'm glad you enjoyed that. Is it possible for someone who's an assistant supervisor to inherit the membership of her mother, who was an assistant manager and has passed away? My dear, if there's a will, I will send that to America, because it normally says you start at the level of the person, but not higher than manager. So I would like to send me whatever you've got. I'll send it to America, and they might even contact the sponsor of the mother, who might be a manager and who might be able, because the person she's an assistant manager and the other person's an assistant supervisor. Send me the information and we'll find out about that. It's Louise. Okay, let's move on to the next question. Thank you, Sheshi, for giving that email address. Can an FBO also register their husband as an independent FBO too, and same succession laws will apply, or do we need only one of us? The application form, Penelope, only has one line, one field for registration. So if you join the business, you can't add your husband to your distributorship, but your husband can only join the business under you. So you will become the husband's sponsor. If you ever become bad friends, he must then join under your sponsor. He cannot go and join under someone completely different. You've got to leave that down line intact. So does that answer your question? You cannot, you only join on your own. Two of you can't join together on the same form. Not anymore. That stopped in 2014. But join the business, and then you sponsor your husband on a different form, on a different number, but he's got to sign up under you or under your sponsor. He cannot sign up under another person. I hope that makes sense, Penelope. How can I fix my email because I joined? Oh, okay, yes. Oh, they wrote the wrong email for me. I don't know whether that was captured incorrectly by a staff member or whether that was done by your sponsor or the person that handed your form in. Sometimes sponsors do funny things, just to get you on the system. They'll give you another email address and then you don't get any notifications. It's actually very sad when people do that. So send us an email, FBO at, sorry. FBO support forever.co.za and give us your full name, your FBO number, and your new email address, and we'll change it for you. Ketty wanted to ask, what happens when the child is over 18 years and is already an FBO and is a beneficiary? Well, then we would, I would send that to America. I would send the will to America naming the child, and I would send details of the child's business. And America would advise them whether to inherit the parents' business or whether to keep their own business. But they won't be able to do both because no FBO can have two numbers on the system. You only work with one number. And assuming, when we look at the law of averages, assuming that the parent is at a higher level than the child and been in the business and maybe has a more successful business, but that send us everything that you have, and or talk to an accountant or an attorney and talk it through. But I can't say, oh, well, let the child must give up his business, because the child might be more successful than the parent. You don't know. So that's something that the child must make a decision on, or send it to us and we'll send it to America and they will advise us accordingly. I hope that answers your question, Ketty. Somi, when signing up a new person online, yes, thank you. That's a very, very good question. I have already written to America and said, when you sign someone online, there's no block to indicate married or single. So I need to know what to do in a case like that. Let's say tomorrow I got the death certificate of somebody that signed online. I would immediately send it to America, because that part, online registration, has not been put into the company policy yet. It might be in the pipeline, but there's nothing there. So thank you. That is a wonderful question, Somi. That is what I will do. I will follow up with that email and ask them. I haven't had any backup on that online registration. Thank you so much. Training. Oh, it's a pleasure. It's a pleasure. As a supervisor, my only daughter is an assistant supervisor. Can I will mine to her? Yes, of course. You don't have to be at any particular level. You're worried about your child, not the level you're on or the level she's on. It's the same as the person a few questions ago, where the mother is an assistant manager and the daughter is assistant supervisor, and the daughter is mentioned in the will as a beneficiary and she also has her own business. Send us everything, and if we either speak to an accountant, depending who's the more active in the business. Your daughter's a supervisor. As a supervisor, your daughter's an assistant. What if in 2 years your daughter is a manager and you are an assistant manager? You don't know what lies ahead. So think about that, and your daughter should carry on certainly with her business, and so should you carry on with your business. But when it comes to the will, if you put your daughter's name in the will, that's fantastic. When the time comes, heaven forbid, send us everything. And if we can't see a way, well, if we see that your business is far healthier, stronger than your daughter's business, well, we would say to her, it's better that you give up your business and take over your mom's business, seeing that you are in the will. Otherwise, if there's any confusion, we send it to America and the legal department will tell us what to do. I hope that answers you. Huseletsa, I have 3 children. You must decide, darling, how the business gets divided. Your will should say something like this. My FLP business, should I be deceased, my FLP business must be divided as between the following 3, and you put the name, and if they're over 16, you put the ID number. If they're under 16, you don't have an ID number, just the birth date. Must get 33 and a third, 33 and a third, 33 and a third. That is 1/3 per child, equal portions. If you want the eldest one to have more, then you put 50% and the other 2, 25%. I can't tell you. An accountant or an attorney will tell you how to split the business between your 3 children. Ah. Sipoki can't wait for the next training. Excellent. We've had it before. But we're going to have it again on the 3rd of September. Only more informative this time. Okay. Oh, excellent, Penelope. Crystal clear. That's wonderful. Okay. Oh, I missed this session. Only have chance to take. Oh, my sweetheart, watch after 1 if you can, or watch it this evening. Earlier on, if you go to YouTube and you go to click on company policies, all the trainings are listed. This program was recorded and will be the one right at the bottom. Or you can go to our Facebook page as well. They're all recorded. It'll be there. You can watch it in your own time. Please repeat FPO support email. There you are. To swallow, look below. Sheshe has put it there for you. Thank you so much, Sheshe, for being so proactive. So when signing up a new person online. Yes, we've discussed that, my sweetheart. We have discussed that, Somi. You've asked that question just a few questions ago. So one can apply online. Yes. So send an email to fbosupport@forever.co.za and say to them, please explain to me how I can do online registration. You can register people online. Yes, we've had training for that earlier in the year. If you are new, just send that email and we'll send you the procedure of how to do that. Now a newborn has an ID number. Oh, wow, Ketty. Well, that's wonderful to know. I didn't know that. I thought they only get ID numbers at 16. Sure. Thank you so much. Wow. Okay, Somi, you signed up 2 new people this month online and they both didn't receive a literature pack. In the staff of the product center ensure this does. Well, the people at the product center don't know that you've signed someone up online. You need to send that email to FBO support. Yeah. When you go to the product center, when you sign up people online, the first order is online. It's an online order. Yeah, I will speak to them. It's the only difference between an online sign up and a sign up via email or over the counter is in the number 270, and online the next number will be 5,000. And that's very easy to not see that 5 there and just see the zeros. So it's good for someone to let us know this, but I will speak to the product center managers, but it's not that easy to especially at month end, to see that 15 there. But let me make a note that when you get the welcome letter and your password, maybe we can copy in the product center and remind them of the literature pack. Thank you. That's a very good question. Thank you so much. Yay, 3rd of September. Noted, will do at YouTube. Thanks, Ntombokolo. Are there any further questions? Because I think our time is up. We're here for another 2 minutes and then our time is up. I've enjoyed doing this very much and I hope that you've enjoyed it. But like I say, send us any questions that you don't have. Pleasure, Somi. Pleasure. Thank you all for your participation. Thank you, Sheshe. You've been amazing, giving us that FBO support email address. Thank you, everybody. Take care. Have a wonderful week. And my colleague Green will be doing the training on the 3rd of September. Take care.